For months, Donald Trump has declared in public and in court that he's effectively above the law, that as a former sitting president, he enjoys some sort of absolute sovereign presidential immunity for life, meaning he can't be held criminally or civilly accountable for the events of the January 6th insurrection. But recently, two different courts said, no, that's really dumb, dangerous, and anti-American. But before we unpack all that, if you haven't yet, please hit that like, subscribe, and the alert bell. All right, folks, this is one of the most deranged arguments that Donald Trump has offered, and it's bad enough coming from him as a former president, as the leader of one of America's two major political parties, and as a guy running for president again with a genuine chance of securing the White House. But even more dangerous is that tens of millions of people across this country seem to be eagerly lapping it up. People who claim to love and support the Constitution and yet just blatantly exalt one person. They want to make one person above the Constitution. If MAGA has to choose between Donald Trump and the Constitution, they have and they will choose Donald Trump every single time. And all of this in conjunction is incredibly dangerous. So it's really important that the courts get this stuff right. And they did in two recent cases. But before I unpack that, I want to play this clip from Donald Trump at a recent rally in which he again alludes to the power of quote unquote presidential privilege or presidential immunity.
Almost all of them were for Sleepy Joe Biden. Only got indicted once. He got indicted. I got indicted 4 times because I'm questioning a crooked election. But we're not questioning it. We know the results. We know it. And when we go through courts, if we ever even have to do it, because you have presidential privilege and also we should never have to do that. But if we do, we want to redo the election only from the standpoint, we want that election, we want to look at it very carefully. We have so much information. There was so much corruption in that election. You take a look, it's incredible. Just the other day in Georgia, 3,600 votes that were duplicated so that you had double votes. Almost all of them were for Sleepy Joe Biden, right? Every single vote. You take a look.
So that's basically the gist of it. Now, before we get to the real meat of the matter, I just want to point out that that claim that Donald Trump is making about 3,600 ballots is neither new nor accurate the way that Trump said it. It was widely reported back in June. We're in December now. He needs to move on. And it's actually not at all what he described. So this is from factcheck.org. In his latest election fraud spin, former President Donald Trump falsely suggested that 3,600 criminally duplicated ballots were counted in Atlanta's Fulton County in the 2020 presidential election. This is important. He is referring to news reported months ago about errors made during an audit, not during the official ballot count. State investigators found that there were double counted and miscounted votes during an audit in the county to confirm the 2020 results. But the audit was never part of the certified tally in Georgia, which Joe Biden narrowly won. Investigators say the errors were unintentional and did not affect the outcome. So they weren't malicious during the audit, and the audit came after the certified results of the election, okay? It was errors made during an audit, not the election. Besides that, I just want to remind everybody that when it came to election fraud during the 2020 election, as was reported in the Bulwark, the Heritage Foundation, a conservative think tank, maintains a public database of ballot fraud cases. A review of the database reveals an astonishing fact. In every listed indictment and conviction for voter fraud and other malfeasance in connection with the 2020 presidential general election, when the culprit's political affiliation is known, he or she turns out to be a Republican or unabashed conservative. And we also have recent reports, Fox News even talked about it, that an Iowa official's wife was convicted of voter fraud to try to get him the victory in the election. And of course, that wife and her husband were Republican, okay? So this idea that voter fraud is exclusive to the Democratic Party and that Republicans don't engage in it is absurd. Now, let's get to the crux of the matter, which is these two recent court cases which undermine the notion that Donald Trump gets a get-out-of-jail-free card simply because he is a former president of the United States. This is a brief overview from Chris Hayes, and then we'll look at some of the opinions themselves.
Good evening from New York. I'm Chris Hayes. We've got huge developments tonight in two of the trials of Donald Trump. Just within the last half hour, Judge Tanya Chutkan, who was overseeing the federal criminal case about January 6th and the attempt to overturn the 2020 election, issued a withering rejection of the ex-president's attempt to get his criminal case thrown out of court. Trump and his lawyers had argued that he had total presidential immunity, and so the case should be dismissed outright. Chutkan rejected that argument, saying in part, quote, defendant's 4-year service as commander-in-chief did not bestow on him the divine right of kings to evade the criminal accountability that governs his fellow citizens. Now, this ruling in that criminal case comes today in the wake of a federal appeals court ruling that Donald Trump can face legal accountability for inciting the insurrection on January 6th in a civil case. That case brought by Capitol Police officers and lawmakers who sued Donald Trump back in 2021. As the Washington Post explains, they brought the suit under a roughly 150-year-old law designed to combat KKK violence after the Civil War. They argue Trump violated that statute, barring the use of force, threats, or intimidation to prevent government officials from carrying out their duties by conspiring with members of far-right groups to keep lawmakers from confirming the results of the 2020 election. Again, similarly, in that case, Donald Trump and his lawyers claimed that, as they had in the federal case to steal the election, that he had absolute immunity as president, that he could not be held civilly liable or accountable for his actions around the attempted coup.
So that's a brief overview of the two cases. So I want to actually look at the opinions themselves. We're going to start with I would say the bigger one in the sense that it came from a superior court, the U.S. Court of Appeals for the District of D.C. Okay, and we're not going to go through the whole thing, but I want to give you the summary of what the judges unanimously held. Since the Supreme Court's decision in Nixon v. Fitzgerald, presidents have carried out their official responsibilities free from any exposure to civil damages liability. Nixon established a president's absolute immunity from civil damages claims predicated on his official acts, meaning if the president, while he's in office, is going to enjoy immunity from civil suits, it has to be because the things that he's being sued for are official acts of the president. The object of a president's official act immunity is to assure that he can fearlessly and impartially discharge the singularly weighty duties of his office. This is key. The president, though, does not spend every minute of every day exercising official responsibilities, and when he acts outside the functions of his office, he does not continue to enjoy immunity from damages liability just because he happens to be the president. Rather, as the Supreme Court made clear in Clinton v. Jones, a president's official act immunity by nature does not extend to his unofficial actions. When he acts in an unofficial private capacity, he's subject to civil suits like any private citizen. And so, they conclude, we answer no, at least at this stage of the proceedings. When a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next, and campaigning to gain that office is not an official act of the office. Okay, you understand? So when a sitting president running for a second term attends a private fundraiser for his re-election efforts, hires or fires his campaign staff, cuts a political ad supporting his candidacy, or speaks at a campaign rally funded and organized by his re-election campaign committee, he is not carrying out the official duties of the presidency. He is acting as office seeker, not office holder, no less than are the persons running against him when they take precisely the same actions in their competing campaigns to attain precisely the same office, okay? And they even point out that when Donald Trump filed various suits pertaining to the January 6th insurrection and the rally that was held by Trump right before the insurrection took place, in which the incitement occurred, that he did so in his capacity as a private citizen running for president, okay? Now, that's huge. Then you have the District Court for D.C., and again, this is a case or a ruling from Judge Tanya Chutkan, who was appointed by President Obama, and she is presiding over the Jack Smith case against Donald Trump for his role in attempting to overturn the 2020 election. Basically, Trump's attorneys tried to get her to kick the case out, citing presidential immunity. And again, we're not going to read the whole thing, but I want to point out some things right there. Defendant contends that defendant being Trump contends that the Constitution grants him absolute immunity from criminal prosecutions for actions performed within the outer perimeter of his official responsibility when he served as president of the United States, so long as he was not both impeached and convicted for these actions. The Constitution's text, structure, and history do not support that contention. No court or any other branch of government has ever accepted it, and this court will not so hold. Whatever immunities a sitting president may enjoy, the United States only has one chief executive at a time, and that position does not confer a lifelong get-out-of-jail-free pass. Former presidents enjoy no special conditions on their federal criminal liability. Defendant may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office. Folks, this is huge. This is just a strict repudiation of this really authoritarian position that Trump takes. And so she also points out, under the defendant's reading of the Constitution, if a president commits a crime that does not fall within that limited category, we're referring to why the president can be impeached, which is treason, bribery, or other high crimes and misdemeanors. That's the predicate for impeachment. And Judge Chutkan points out, Trump's reading of that phrase is that if a president commits a crime that doesn't fall within that limited category, and so could not be impeached and convicted, the president could never be prosecuted for that crime. Alternatively, if Congress does not have the opportunity to impeach or convict a sitting president, perhaps because the crime occurred near the end of their term or is covered up until after the president has left office, the former president similarly could not be prosecuted. Defendant suggests that this scenario, in which the former president would be utterly unaccountable for their crimes, is simply the price we pay for separation of powers. Deranged. This idea, like, listen, unless it's bribery, treason, or high crimes and misdemeanors, it's something like murder or tax fraud or whatever, or something, Trump gets a get a jail free card for that. That's insane. Who on earth would make that argument? Who on earth believes that that is what the founding fathers or any amendment framer believed by the president? Again, we talked about this before. The sitting president logically enjoys certain privileges. Of course, he is the most powerful person in the country. He's the head of state. He's the head of government. It makes sense that you can't be in a position to just drag him in court every damn day for any reason. I understand, we all understand, that certain accommodations have to be made. But Donald Trump is not the sitting president. He is a former sitting president. And what's just bewildering is this idea that he could just do anything when he's in office, and even when he's no longer in office, enjoy the protections of that office. It's so bizarre, even if what he did was criminal, openly criminal. Donald Trump famously said that he could shoot someone on Fifth Avenue and not lose a single vote. To me, this is almost like the legalese iteration of that. It's just an ethos of unaccountability. And it's so scary that so many Americans eagerly support this. If you look at Twitter, or if you go to OAN or Newsmax or Fox News, conservatives are furious about these rulings. They think that it's somehow, they're coming after Donald Trump. No, they're saying that nobody is above the law in the United States of America. Nobody should be above the law in the United States of America. And I always think to myself, what if Barack Obama filed a case like this? What if Joe Biden eventually files a case like this? Like, listen, I was the president once, and basically that means I'm a king. I have the divine right of kings to be above the law. Nobody would accept that. Certainly not the right, but I would argue the vast majority, if not the totality, of the Democratic bloc either. I wouldn't want that, and I'm a Democrat. Joe Biden shouldn't be above the law. Barack Obama shouldn't be above the law. Donald Trump, when they are sitting presidents, should they be granted certain temporary immunities? Sure. But it's not absolute. It's not lifetime. That's something reserved for kings in other countries. King George III of the United Kingdom, he is at least on paper above the law, because in the United Kingdom, the source of law is the sovereign, is the monarch. It's a very strange, role play interpretation. Basically, as the monarch, King George is the embodiment of law, and therefore the law can't be used against him. He can't be used against himself. He can't be held accountable to himself. That's sovereign immunity, okay? We are not a monarchy. We are not a constitutional monarchy. We are supposed to be a constitutional democratic republic in which everyone is below the law. Everyone is beneath the law. Everyone has to comport with the law, because the source of law is the Constitution, not the president. So these are two critical defeats for Donald Trump. I'm sure he will appeal. I'm sure he will fight every step of the way. But at least so far, this means right now he is open to not only criminal prosecution, but also, as Chris Hayes points out, civil lawsuits about his role in the January 6th insurrection. And some have even speculated that if those go through, he could be sued into bankruptcy. So let me know what you think in the comments.